Good morning. Welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We are located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 a.m. to bring you valuable information that landowners need regarding the Marcellus shale and natural gas development here in Pennsylvania. If you are looking for the landowner information show, this is the show for you. At the Clark Law Firm, I focus on landowner and only landowner representation, and I have and continue to represent landowners all across the state of Pennsylvania for gas lease issues, lease negotiations, pipeline water line agreements, and of course, royalty deduction, royalty challenge issues. I'm going to talk more about that today. Estate planning, doing a lot more estate planning for my clients as they're transitioning, and other Pennsylvania landowners who are becoming clients for the purpose of estate planning. But as clients transition into the royalty phases of their lease, it's very important that we're looking at what is their succession plans for their children, grandchildren, and so on. So we're doing a lot more of estate planning work. I do a lot with gas lease amendment and modifications. A lot of landowners are being approached, asked by the gas company to amend or modify their existing lease, and that can be tricky, and it's very important. You'll hear me say this quite often. Whether it's me or somebody else, please make sure you're getting help with these issues. It's a big part of the show is we want to make sure that we're identifying issues that you should be thinking about as you go forward. So, if you're approached, for example, a gas lease modification or amendment, it is very important that you understand the terms of that amendment, understand the terms of your original lease, understand the terms of the amendment, and then also, of course, how is that amendment going to impact your lease. These can be very complicated documents. If you've seen them, sometimes it'll say something like the second paragraph or second sentence in paragraph 6 on page 4 is amended to read blank, and it can be very, very tricky, and it's like almost like a puzzle, sometimes a very difficult puzzle to follow. So you want to make sure that you understand all the terms, but also, unfortunately, on many occasions, it may be in your best interest as the landowner to go ahead and agree to that amendment and modification. Now, I said maybe. It's really important that you understand these things because there's never one piece of advice or one solid, easy answer that's going to apply to everybody. So these amendments and modifications, again, if you're given one, please make sure that you understand it, that you're looking at it, and that you're getting some help with it, because these things can be very tricky, and it is a big concern of mine as to, are people really looking at these? And a lot of times people say, hey, I'm not even going to sign this, I'm going to throw it away, I got you gas company now. Well, be very careful, because that's not always the case, and it may be in your best interest to sign it as presented. It may be something that you're able to negotiate and get some of the terms changed. So we want to look at that as well. So if you are in need, and this is my only commercial part really, I think, well, hopefully, of the segment, hopefully for you guys, but if you need representation, if you have questions on these issues, and you'll hear me say throughout too, that if you want to get some advice or you want a free evaluation on, is a gas company, in my opinion, unauthorized in their activity and inappropriately taking royalty deductions from your oil and gas lease, you can call. I'll give you a free confidential evaluation with no obligation. But if you have a pipeline agreement, I say often, I've negotiated pipeline right-of-way agreements now with over 40 separate companies all across the state of Pennsylvania. So if you're in need of any representation, if you want that free evaluation regarding your royalty payments, is a gas company improperly taking royalty deductions? In my opinion, you can contact us anytime at 570-307-0702. Again, that's 570-307-0702. And remind everybody, just last month, we were coming up kind of on our month anniversary, switched over, used to be doing the show in a different station, started doing some news stations, and now our area of coverage is so much better, I think, at this time. We're hitting through Bradford County, Wyoming County, Susquehanna County, Lycoming County, all of these counties being areas where I practice, in Montrose, Towanda, Athens, Sayre, all of these different areas where we weren't necessarily hitting in Wyalusing now where we are with the radio show. So you can tune in every Sunday from 8 to 9 a.m. Check it out there. But also, what I started to do now, too, we have a couple websites, and landowners find these very informative websites. So I really encourage you to check them out at pagasleaseattorney.com and pipelineattorney.com. And what I do is, we've got a new system, too, so it's working out pretty well. I take today's show and we post it up on the website tomorrow. So tomorrow, Monday, you can go to the website, check out the show, and if that isn't exciting enough, we have radio shows dating back to August of 2010. So there's 140 some shows that are available online, but I've been doing this show since August of 2010, and just this week, a guy asked me, another attorney said, geez, you've been doing it that long. What in the world do you talk? How do you come up with stuff every week? And I laughed and I said, I got a big expandable folder. And I had to get an expandable folder because all the paper was falling out of just a regular folder with ideas, topics, items to talk about. And you as a landowner, if you're interested in anything and you want me to hear me discuss it or give some education, hopefully on it, or information, you can email me through the website at pagasleaseattorney.com or pipelineattorney.com. You can send, there's a place there for questions, topics. You can send something out there, and I'll look to address it as soon as I can on an upcoming show. Again, I am Attorney Doug Clark, and you're listening to All Things Marcellus, and we're here every Sunday from 8 to 9 a.m. Okay, with that, I've talked about the last couple weeks, and I'm going to continue to talk about today royalty deduction issues. It is the hot issue. I've talked a lot about pipelines and modifications in the past, and I will again here coming up in the future, but there is a lot going on with the royalty deduction issue. So I want to make sure that I'm really explaining and giving everybody the information, like I said, that you need this. You need to understand this. Whether you're leased to Chesapeake, whether you're leased to Cabot, Southwestern, WPX, EOG, you name the company, you need to understand these issues. This is so very important. So what I want to do, again, and bear with me because I'm going to quickly reset kind of what the issue is, and then I'm going to get into a couple more examples. I did one last week, but I'm going to get into real life examples for landowner clients of mine who are getting royalty checks. And I'm going to talk today some more about one client who's getting royalty checks not from Chesapeake but from a different company. And we're going to walk through their check, and I'm going to explain if this proposed class action settlement, and I call this the Demchak settlement, that's the name of the plaintiffs, and it was filed in federal court. What is happening right now with this landowner who would fall into this class of people who have this relevant language in their lease? So what is occurring right now when they're leased not to Chesapeake, to a different company? And how are they being paid, and how are their royalties being calculated? So I'm going to talk about that, and then we're going to talk about, what if their company applied the Demchak settlement to them? Now, they wouldn't be able to just simply do that, but just to give an illustration of, okay, so you're out there, you say, hey, I'm leased to Southwestern, Talisman, WPX, Cabot. This doesn't apply to me. Well, we want to talk about, what happens if your company changes positions in the future? And then just hypothetically, what would be the impact if the settlement was reached just under the same terms, or there was an agreement reached under the same terms of the Demchak settlement? So it also is a good illustration, because a lot of people, I talked to some guys this week too, who said, hey, I like what you're doing. I don't like the terms of this settlement. I don't think this is a good deal for landowners, but I'm not even getting royalty checks yet. I'm leased to Chesapeake, but I'm not even getting royalty checks yet. And I explained, well, look, this still would apply to you. And he says, well, I understand that, and I appreciate that, and at first I didn't think that, but it will apply to me. He understands. So he says, but I just don't have any idea how much money or what this really means, and I'm not sure how involved I want to be or what I want to do. So that's another item here too. I just want to give an example here. Now, a couple things, and to me, I'll be honest, I understand that reasoning, and I know that's tough for a landowner who's not getting royalties at this time, but remember, this applies to you regardless. So whether you have $100 in deductions for post-production costs in a given month, or $1,000 in a given month, or $10,000 in a given month, the settlement would apply to you equally. So if you're getting, as a landowner, 27.5% of these post-production cost deductions under the settlement, well, if it was $10, you'd be getting $2.75. If it were $100, you'd be getting $27.50. And we can keep doing the math. If it was $1,000, you'd be getting $275. So that's going to be, so I recognize you don't know how much money you're getting, but we do know what the percent is going to be. And our position is, hey, that percent isn't high enough. So I'm going to talk about a real life, real client, landowner client of mine who's getting royalties from another company, and what is he getting now? What would be the difference if this settlement was applied to them? And then we're going to extrapolate or push out those numbers just to illustrate what this could be and the type of impact that it could have on one single landowner. Then I'm also going to take a client of mine who is leased in part, well, Chesapeake has a lease. Chesapeake has assigned a portion to Statoil. I'm going to talk about their case and explain how, and this is a severe case, just how much is being taken out of their check for deductions in this given month, and explain the difference if there were no deductions, if they were being paid royalties by companies like Statoil only, Mitsui, Southwestern, WPX, Talisman, these other companies, if they were getting royalties from them, what their royalty would be with no deductions being taken. And remember, this particular individual, and every individual in Pennsylvania who is leased to Chesapeake, and Chesapeake assigns a portion of that lease to Statoil, this person receives a check from Chesapeake and Statoil. Their Chesapeake check right now has 100% of these costs, post-production costs, being deducted. The Statoil check has no deductions whatsoever, none whatsoever. And as I say all the time, and I'm sure I'll say again today, I am extremely concerned where if this proposed settlement were approved as the way it's written, what will Statoil do? Will they start taking deductions? And when I review this release, which is part of the proposed settlement, I have some questions. Again, I have some questions. Could this lease even apply to Statoil? Could it? So, there's a lot of concerns there. This settlement is very complicated in a lot of ways. In some ways, it's pretty simple. But in some ways, when we get into the release, and what does Chesapeake get? What do they get by entering into this settlement and paying the landowner 27.5%? Well, one thing they get for sure is they don't have to pay 100%. They resolve this case, but they also get what's called a release of claims. So the landowner says, in exchange for getting this, or the settlement says, in exchange for getting the 27.5%, there are certain things that I'm going to give to you, the company, and they involve, and we're going to talk about that some today, and I'm really going to get at that to future shows as well, but they're going to get releases for claims that you can't go back and challenge Chesapeake. And one of the things, I'm going to leave you with this, and you may find this kind of scary, but one of the things that's in this settlement release, and if you look it up, it's under section, it's under 6.7 of the settlement release, and it states, in part, the parties, that would be Chesapeake and then the class, expressly agree that future royalty calculation method, the future royalty calculation method, applies, notwithstanding any current or future law. Notwithstanding, meaning in spite of, despite any current or future law, statute, judicial decision, or rule regulating the payment of royalties in Pennsylvania. So again, this says that the parties expressly agree that the future royalty calculation method, what they say here, the 27%, 27.5%, applies despite any current or future law. And remember, we have a very important House bill out there pending, so this gets very, very tricky. I am Attorney Doug Clark. This is All Things Marcellus. We're going to get into these examples right after this break. Hello, and welcome back to All Things Marcellus with me, Attorney Doug Clark. And reminder, We are here every Sunday. I am here every Sunday from 8 a.m. to 9 a.m. every Sunday. And then we archive the radio shows on my websites, especially the number one site, the most popular one is pagasleaseattorney.com. I also have the website pipelineattorney.com. So if you're looking at pipeline issues, check that out, pipelineattorney.com. But pagasleaseattorney.com, you can go there. Starting on tomorrow, Monday, we will be running the shows. They'll be available then, archived there on the website. I've been doing the show since August of 2010, so we have 140 plus hours of shows available there. So certainly something to keep you busy on a rainy day. But we'll have this show up. And if you're interested in this issue, I've done many shows on this topic because it is so important, and hopefully you'll get even a better grasp of how important it is as we go through this next segment, or next couple segments here. So I want to jump right into that, and I want to get in and say, okay, so what are we talking about here? And reset the table. We're talking about people who are having post-production costs deducted from their royalty check, and whether that is appropriate, whether it's authorized or allowed under the terms of their oil and gas lease. Well, the first thing we need to do is I need to look at your lease, or you need to look at your lease and say, all right, what does my lease language say, and do I feel that the company can do what they're doing? So what we have is there is certain lease language, and it's commonly referred to as the market enhancement clause, but that concerns me because it's not simple, just that simple. There's similar language that also applies, and you may never see the term market enhancement clause in your lease. You might not even see the term market enhancement. You might see language talking about, is the gas ready for sale or use, and there be no deductions. There's a lot of different ways it's written. So that's why I offer this free, confidential, no obligation evaluation. You send me your lease. If you're getting royalties, send me the royalty statements from from the companies which are receiving royalties, and I'll get back to you in writing and let you know whether I feel the company is inappropriately taking deductions. Do you fall into the class that would be covered by this proposed class action settlement, which we have intervened in and we're objecting to? And then also we have our arbitration case moving forward, where everything is stayed at this moment as we go into this mediation process. But we currently represent 160 clients, 160 individuals, consisting of over 5,000 acres, and I believe that number is going to increase here in the next week or so, as I have some other clients who I believe are going to be signing up to contest this proposed settlement and also to support and to join into our arbitration action. So again, I offer free, confidential, no obligation. There's no pressure. You don't have to do anything. You just get the answer because you should have the answer. You should get the materials. You should understand this. You can go to the website, pagasleaseattorney.com. We have a whole segment dedicated to the website, a lot of filings there, but do your own research if you want as well. But contact me 570-307-0702 for that free evaluation. And again, confidential, no obligation. I want you to understand, does this apply to you? You make your own decision after that, whether you want to do anything, whether you don't want to do anything, but learn and find out, does this apply to you? Because it's so important. Many people are standing on the sidelines not realizing what is at stake here and even whether this even applies to them. So 570-307-0702, or you can send in your paperwork. I'll get back to you usually within a week to 10 days in writing and let you know what my opinion is, and then you make your decision, like I said, from there. Okay, so real quick as I can, I want to just outline again the proposed settlement. Post-production costs, what are they? Generally speaking, they're the costs that a company incurs from the surface, the wellhead, when the gas exits the ground at the surface, and costs are incurred in order to gather this gas, transport it, maybe dehydrate it, compress it, and similar type cost to get the gas from the wellhead to this interstate transmission pipeline. That being a pipeline like the Transco line, the Millennium line, the Tennessee line, these bigger pipelines that go across the state to state, interstate. So we're talking about those costs there. Now, can a company deduct those? And in some cases, based upon the current law, and unless legislation is passed, it appears that companies certainly can, depending upon the lease language. But what we're talking about are language or leases that have language such as the market enhancement clause or similar language. Again, similar language. So if you look and you don't see market enhancement language or market enhancement clause, that doesn't mean this does not apply to you. And that's why I say it's important that you get this evaluation and you understand, does this apply to you? So if you have this language, we assert and we take our position that the company is not entitled to take any deductions at all for gathering, transportation, compression, dehydration, and the list goes on. Most companies that we see, if you have this language, do not take any deductions. Again, most companies do not take any deductions, but Chesapeake takes 100% completely, deducts all of these costs from landowners' royalty checks if you have the market enhancement clause, the ready for sale or use clause, or similar language. So I say this all the time. Statoil, under the same lease, under the same exact lease that they share with Chesapeake, same lease, doesn't take any deductions. Chesapeake takes complete, full 100% deductions. So what happens? We file an arbitration case in April 2013 because that's what the leases call for. We're proceeding with arbitration, and then on August 31st, there's a proposed settlement filed, a complaint by Chesapeake and these other attorneys in this case, which we call Demchak versus Chesapeake, in federal court in the Middle District of Pennsylvania. We were unaware of anything even going on, and this occurs, and all of a sudden it's filed. So we then intervene and say, hey, wait a second. I think at that time we represented 89 individuals in our case. This other proposed settlement, they had, I believe, 13 individuals. So we object and we intervene. Now, at this time, again, we have 160 clients, and that number grows. We represent over 5,000 acres, saying, hey, wait a second, this is not a good settlement. This is inappropriate for all these different reasons, and this number should be much higher and a lot of other reasons. So we're proceeding onward, and the court, despite what was written, unfortunately, in that first article, and then other newspapers, amazingly, obviously they follow whatever they read before, but there was a proposed settlement in Demchak. That proposed settlement was never approved, wasn't preliminarily approved by the federal court. The court has done nothing with it. It's been sitting there since August of 2013. So we've obviously have had success in stopping what we think to be a very inappropriate, unfair settlement to landowners. And many landowners have joined and said, hey, yeah, this isn't appropriate. This isn't right. So what we're looking at is now let's talk about, well, what are the terms of this settlement? It is a class action settlement. So you can be involved if you have the terms involved here. If you're leased in whole or in part to Chesapeake and you have the market enhancement clause or similar language, you're within this settlement, regardless of whether you're receiving royalties. So you would have a choice if it went through the way it is and it were preliminarily approved. You as a landowner can do nothing and be a part of this settlement, or you can do what's called opt out and say, hey, I don't want to be a part of this settlement, but then you're going to have to challenge the company individually. So we're saying, hey, wait a second, these numbers are just way too low. How this occurred wasn't the proper fashion, and we feel that these numbers must be much higher, and certainly our clients demand that this number be higher, these figures be higher. So what are these figures? Well, what they have is there's an important date, and we'll say September 1st, 2013. That's September 1st, 2013 is a very important date, because what the settlement says is if you have this language and there were deductions taken by Chesapeake prior to September 1st, 2013, Chesapeake will refund you those deductions at a rate of only 55%. They're not going to give you that full deduction total. They're going to give you 55% of what they've taken. So what happens then also, the attorney fees in this case, in this proposed settlement, the attorneys are requesting 33 1/3 or 1/3 of the recovery for all prior deductions taken. So Chesapeake would pay you 55%, but after attorney fees, you would actually get, as the landowner, you would get 36.68%. So about 37% of the money that was taken. So if there were $10,000 of deductions taken in the past, if this were approved the way it is, you as the landowner would receive around a little bit less than $3,700. Again, if you had $10,000 of deductions taken by Statoil, Mitsui, WPX, Southwestern, Cabot, Talisman, you would get $10,000, not the settlement amount. So, okay, not that drastically lower $3,700 amount that we just talked about after attorney fees. So, that's the back payment. Now, what happens in the future? Well, from September 1st, 2013, so going forward, you would not get 55%. That's only backwards that you go, looking back, that would be 55% of a refund. 55, not 155. Going forward, though, then the company would pay the landowners 27.5% of these deductions, and they would keep 72.5%. 72.5%. So, what that means is for future royalties moving forward after September 1st, 2013, Chesapeake would then deduct, instead of deducting 100%, they will deduct 72.5% of all post-production costs for the lifetime of the lease. For the lifetime of the lease. Not a designated time frame. As long as there's a lease, that's what they'll take. So if you have one well now and you have 6 wells coming, 10 wells coming, this applies to all wells for the lifetime of the lease. So this, again, we're assuming this would be approved in the way that it's written, which I'm optimistic that hopefully as we contest this, we're not going to see that occur. So, okay. So moving forward from September 1st, going forward, then the payment would be, if this were approved, of the deductions of these post-production costs, the gathering, transportation, which can be excessive, and we'll talk about that. Of those deductions, the landowner would receive 27.5% of those deductions from September 1st for the 2013 through the lifetime of the lease. Now, just to point out, the attorney fees that are requested are 33 1/3%, or 1/3 of this amount for a total of for a total of 5 years. So, for the first 5 years, if this were approved, instead of the landowner receiving 27.5% of the money that's being deducted, after the attorney fees for the first 5 years, if this were approved, the landowner would receive 18.3%. So just to give an example, if this was $1,000 in a given month, the landowner, for the first 5 years, if this were approved, the landowner would receive $183 out of the $1,000. After 5 years, the landowner would get 27.5%, or they would get $275 out of the $1,000 that was being deducted. Remember, this applies for the lifetime of the lease. Statoil, Mitsui, WPX, Cabot, Southwestern, and Talisman would not take any deductions. Not take any deductions. And remember, this settlement applies to anyone who is leased in whole or in part to Chesapeake. This proposed settlement, anyone who is leased in whole or in part to Chesapeake, whether or not you are receiving royalties, whether or not you're currently receiving royalties, you need to know, does this apply to you? And also, critically, that you have the market enhancement or similar language. If you want to find out if you have the language, contact me anytime. I want to make sure people know you're under no obligation to do anything, but get this information. You owe it to yourself to have this information and then make your decision. Whatever you want to do, but get this information. You can do that. I'll let you know. Right back to you. Send me your royalty check. Send me your lease, and if you're getting royalties, send them to me, and I'll just look at it. I'll get back to you, confidential, won't tell anyone, won't show anyone. You can reach me at 570-307-0702. It's 570-307-0702. We get back, I'm going to go through some checks and explain how does this apply realistically. I mean, let's talk practically. What does this mean? I'm going to explain that to you. We get right back. You're listening to All Things Marcellus with me, Attorney Doug Clark from the Clark Law Firm. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And reminder, we're here every Sunday from 8 to 9 a.m. And if you miss any of today's show, go to the websites, go to pagasleaseattorney.com. That's pagasleaseattorney.com. A lot of great information. Just get some information there as well. But we have the show archived. We'll post it up tomorrow on Monday. It'll be up there and it'll remain up there. But each week we will have access to the prior week's show and access to 140 plus hours of prior radio shows. I've switched stations recently in an effort to make sure that we're getting a lot more information out to people who need it. And also, you can go back because I have been doing the show since August of 2010, so we have 140 plus hours up there. So if you're interested in pipelines, leasing, lease modifications, this royalty issue, go check it out. Listen to whatever you want to do at your convenience. We're also on iTunes. You can go to the podcast section, 100% free. Just go check it out. You can type in All Things Marcellus, check out the prior shows. And, if you're interested in Twitter, you're one of those guys, we're active on Twitter. You can find me at Doug Clark Law. It's at Doug Clark Law. And I tweet articles. We tweet what the show topic is going to be. A lot of information like that. So you're going to go check out. We keep on top of things and we get information out there as well. So we got a bunch of followers there. And again, if you have a topic or you want to hear something on the show, if you go to pagasleaseattorney.com, email me something, the topic, and we'll let you know, and we'll get back to it, and we'll try to get you something on there and talk about it in upcoming shows. I'm looking always for hot topics and things that you, the landowners, are interested in hearing about and learning about. Okay, again, this is Doug Clark, All Things Marcellus, and I want to talk about now, we're talking about this settlement. You're hearing me throw out all these numbers, so you know what I'm going to do now? Throw out some more. And what we're going to do, though, is I'm going to give you this. What I'm taking here is, this is a client landowner of mine, took one of their checks for 1 month, and they are leased not to Chesapeake, but to an entirely different company. They have the market enhancement clause or similar language that this proposed Demchak settlement, if they were leased to Chesapeake, this would apply to them. The Demchak proposed settlement would apply to them. But thankfully, they're not leased to Chesapeake. They're leased to another company who does not take any deductions whatsoever. None. No deductions. Where Chesapeake takes 100% of deductions, and their proposed settlement would require Chesapeake to pay, after September 1st, 2013, only 27.5% of what these post-production costs are for the lifetime of the lease. For the lifetime. So this company would pay you 100%. Chesapeake would pay you 27.5%. So let's talk about what do these numbers mean. Okay, well, this client is, fortunately for them, in a nice area. They're getting some really nice production totals. Please understand that this isn't everywhere, but this is a nice area and one that does a good illustration of what I'm trying to convey here. So in this particular case, this client, now there's going to be a lot of numbers. I'm going to round some of these, not get too into the cents of 10 cents, 17 cents, something like that, because I want to make sure that we're able to follow this and understand. So my client in this case received royalties of $19,014 in this given month, a lot of money. So no deductions were taken. However, this company shows on the royalty checks what these post-production costs would be if they were taking them, but they're not. So you're seeing, what would we take, company? What would they take if there were deductions for gathering, transportation, compression, dehydration, and so on? That makes me a little nervous that they're showing this but not taking it. What if they switch positions in the future? Especially, we know they're keeping a close eye on what's going on here with Chesapeake. So, okay, in this case, the landowner received $19,014 in a given month for their royalty check. That's what they got. That was the check that they deposited in the bank. However, the deductions, which the company shows on the check but doesn't take, were a total of $3,732. So that's $3,732 that the company showed in deductions for one given month. So if this gentleman were leased to Chesapeake, instead of getting what he received, $19,014, he would have had deducted the full amount of deductions for that month, which totaled $3,732. So his check, instead of getting $19,014 like he did, Chesapeake would have only paid him, as it stands now, $15,281. So Chesapeake would pay the landowner $15,281, where this company, under the same exact lease, pays him $19,014. So that's how this goes right now. So he's obviously very happy that he's not leased to Chesapeake, because the company he's leased to doesn't take any deductions whatsoever. So he is getting, in this given month, because he's not leased to Chesapeake, $3,732 more in 1 month. Simple math, you play that over time, so you times that $3,725, we'll say, times that by 12, that gives you a deduction for a year of $44,700. That's just one situation here. Okay, now another thing I should have pointed out earlier, I want to make sure everyone understands. This particular case, this guy I'm talking about here, this landowner I'm talking about, there are 2 wells involved here. 2 wells. So not 1, but 2, and certainly not 6 or more. So there are 2 wells for 1 month of production. 2 wells, 1 month of production. So, okay, we explained that if they were leased to Chesapeake, instead of getting the $19,014 he's getting right now, he would only get $15,281. Chesapeake at this time would take 100% of the deductions for this given month, which were $3,732. Okay. Now, well, Chesapeake is saying, hey guys, look, we're looking to settle this case with our client, our landowners. So what do we want to do? Well, despite the other companies would pay 100%, Chesapeake is saying, all right, this proposed settlement that we're contesting, this proposed settlement says Chesapeake, in a case like this, would pay this landowner, instead of 100% of the money, only 27.5%. The Chesapeake would keep 72.5% of these deductions. So what does that mean in this landowner's case? Well, again, he's not leased to Chesapeake, but what if he were? What if his company ended up doing what Chesapeake is doing, and this their case ended up settling for the same type of proposal? Okay, what would that mean? Well, in this particular case, the Demchak settlement were applied. The gas company keeps 72.5% of the total deductions, which in this case were $3,732 in this month. So the gas company, Chesapeake, under Demchak for this case, Chesapeake would deduct $2,706. So instead of deducting, as they would now, $3,732, Chesapeake would deduct $2,706. So that would be then, after the settlement, Chesapeake would then pay the landowner out of the $3,732, out of those total deductions for this one single month, the landowner would receive 27.5% of the total deductions, or a grand total of $1,026. Let me go over that again then. So right now, this gentleman is not leased to Chesapeake. His payment for this month, for 1 month, was $19,014. That's what he got from the company with this language and takes no deductions. As of this month, Chesapeake, well, if the settlement, or what they have been doing and what they are doing, is deducting 100%. So they would deduct $3,732 because that's 100% of the deductions in this given month. So if the settlement were approved, instead of deducting the full $3,732, Chesapeake would deduct $2,706, giving the landowner a total, instead of the full $3,732 in this month, they would give the landowner only $1,026, where the other companies, in this particular case, is giving that landowner the full amount, 100%. So if you're leased to another company who doesn't take deductions, you're getting that full 100%. So what happens is, if you're leased, and what this landowner gets now, to sum it up, right now no deductions are taken. This proposed settlement would apply to this person if he were leased to Chesapeake. So right now, in 1 month only, he received $19,014. Chesapeake, with taking full deductions, would only pay him $15,281. After the proposed settlement, if it applied to this particular case, the landowner would receive $16,308. If no deductions taken, the gentleman receives $19,000 roughly. With 100% deductions taken, he receives about $15,300, just rounding a little. So $15,300 with 100% deductions, and what Chesapeake would do now. After the settlement, instead of receiving $19,000, the landowner would receive $16,308. Okay, that's again doing a little bit of rounding to make it easier to follow. Remember, this is one landowner. This is one single month. The company would keep out of the total deductions under the Demchak settlement. In this case, total deductions were $3,732. The company keeps $2,706. The landowner only gets $1,026 out of the total deductions. And again, if this landowner were leased to Southwestern, Cabot, Talisman, WPX, Mitsui, Statoil, there would be no deductions taken. They would receive $3,732 extra for the post-production cost, and Chesapeake, though, after the settlement, would only pay them $1,026. All right, when we get back, I'm going to talk to you about an actual Chesapeake client and talk about the type of deductions that we sometimes see and what this settlement would mean to this type of individual. We'll be right back. You're listening to All Things Marcellus with me, Attorney Doug Clark. We'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. Reminder, we're here every Sunday from 8 to 9 a.m. You can also check out this show if you missed any of today's show or any of the shows dating back to August of 2010. 140 plus hours are available at pagasleaseattorney.com. Just go to the website, pagasleaseattorney.com. And again, hopefully you're seeing the importance of this issue. I really hope that everyone is seeing the importance of this issue. If you want an evaluation, free, confidential, no obligation, you don't even have to talk to me. You can send me the information. I will get back to you. I need a copy of your lease to let you know, does this apply to you? And if you're getting royalty checks, send me a copy of the royalty checks for just 1 month is fine from any company that's paying you royalties, and I'll give you my opinion as to whether the company is inappropriately taking royalty deductions. Just give you an example in that last segment of a real client of mine who is leased to a different company but has this language in their lease, has this market enhancement clause or similar language. This other company, as many other companies in Pennsylvania do, this company does not take deductions, does not take any deductions from this landowner because he has the market enhancement clause or similar language. No deductions. But if this settlement is approved, if this thing goes through, and again, we're contesting that. We have 160 individual clients, over 5,000 acres that we're fighting this settlement. If this goes through, what will these other companies do? Are they going to continue to pay the landowner? Are they going to continue to give you 100% of this money when their competitor in the state and neighboring units at times is only giving the landowner 27.5%? For the lifetime of the lease? Does it make sense that the original company that you're leased to, who is not taking deductions under your lease with the same exact language, are they going to continue to give you 100%? And I just gave you that example in 1 month in that last case, 1 month. and it was only 2 wells in 1 month. The deductions for one single month were $3,732. That's 1 month. Over a year, that's about $44,700 for one landowner. One landowner and only 2 wells involved here. So if there were 6 wells and you want to really play that out, if all things were equal, then that number's times 3, so 44,000 times 3. Now you're talking about $120-some thousand in 1 year. So again, that's just one individual we're talking about deductions. Okay, let me switch gears. I want to talk about a Chesapeake client. Now, in this particular case, real landowner client, a client of ours in the action against Chesapeake, who's a part of our motion to intervene and part of that process and challenging the settlement. But these are real numbers from a client who's absolutely 100% impacted and who is challenging this as part of who we're representing. So in this case, these are real numbers. Now, these deductions here are substantial. Chesapeake is taking substantial deductions, and there are other people who are seeing these same types of deductions. We're not seeing this across the board, but this is a true, legitimate, 100% accurate situation with a client who's getting deductions from Chesapeake. So right now, this landowner, there is only 1 well at issue. Remember that, 1 well at issue, and this proposal covers the lifetime of this lease, each and every well, forever, as long as it's done under this lease. Okay. Royalty deductions. In this given month, if there were no deductions for this client with 1 well, he would receive, his royalty check would be $2,779. Okay, so about $2,800. So $2,800. The total deductions that Chesapeake has taken in this month out of $2,800, again, rounding here slightly, out of $2,800, Chesapeake is taking $1,719. So again, his royalty check, if no deductions, if he was being paid by Statoil, Mitsui, WPX, Talisman, Southwestern, Cabot, he would be getting $2,779. However, since Chesapeake is paying him, they're deducting from that $2,779. From that amount, they are deducting $1,719. Full 100% out of $2,779. They are deducting $1,719, giving the landowner in this month, instead of the full amount, instead of $2,779, they're giving him $1,060. $1,060. They're deducting out of $2,779, they're deducting $1,719, giving the landowner only $1,060. If he were leased to a different company who treated this in a different fashion, like many others do, instead of getting what Chesapeake gives him of $1,060, he would get $2,779. Let's apply this proposed DemCheck settlement to this case. So going forward, and we're going to eliminate attorney fees, if the DemCheck settlement were approved the way it is now, okay, let's run these figures through and apply the DemCheck proposed settlement. Resetting then. So no deductions taken, the landowner would get $2,779. Right now, Chesapeake takes 100% of deductions. So the landowner is only getting, and this is a check, he's getting $1,060. Out of $2,779, he only gets $1,060. Well, you say, okay, well, we have the DemCheck settlement. What is that going to do? Well, after the settlement, remember, Chesapeake will keep, out of those deductions, they keep 72.5%. Even though other companies don't take any deductions, they're going to keep 72.5%. The landowner is going to get, then, on the other side, 27.5%. So in this case, Chesapeake will keep, out of the $1,719 that they take now for the deductions for gathering and transportation, compression, and so on, they will keep $1,246. So of that amount of money in issue, of the $1,719 at issue, that's how much the post-production costs are for one well in 1 month here. So of that $1,719, Chesapeake, after the settlement, would keep $1,246. The landowner would keep, or would receive, where they're getting nothing, they would now get $472 out of the $1,719. The landowner would get $472. Remember, other companies, Statoil, Mitsui, WPX, Cabot, Southwestern, to name some, would give that landowner $1,719 because they don't take deductions. After the settlement, Chesapeake will give you $472. This is one single well at issue in this case. One well. What I mean by that is, remember, this settlement would apply for the lifetime of your lease. 20, 30, 40, 50 years. However long this lease is alive, this would apply to, or apply for. So this landowner also only has one well. So if there were 6 wells producing, and sometimes there may be 10 or 12 wells planned, but we'll use 6 because that's a number we see. Sometimes it's less, but very often we see 6 wells being permitted or planned. So again, what that means is, this is an example. This shows how it's just in the infancy of this process. This is only one single well. If there were 6 wells, and there would be a lot of variables, and please recognize that, but if there's 6 wells, you can times these, just for explanation purposes, times these numbers by 6. Magnify these numbers. Extrapolate, point further, play these things out. And remember, this is 1 month. Think about applying this for 20 years. This is 1 month and one single well. 1 month, one well. What do these numbers total up to when you're talking about 20 years and 6 wells? 30 years, 10 wells. What does it total up to? This is very concerning. Very concerning. And that's why I say you have to understand, does this apply to you? You have to understand, what does this mean? You have to understand, what are your options? You have to understand this. And whether you talk to me or you talk to somebody else, whatever you do, please understand this. Understand these issues. When you play this out, there are thousands of leases impacted. We represent 160 people now. There are thousands of people impacted by this. In my opinion, this is a terrible situation for Pennsylvania landowners. That's my opinion. You could come to a different opinion, but come to an opinion. Get educated. Understand this. There's a lot of public information available. You want a free evaluation. You want to know whether this applies to you? 570-307-0702. Call me anytime. We'll give you a free, confidential, no obligation evaluation. 570-307-0702. Believe me, you do owe it to yourself and your children, your grandchildren, to understand this issue and make your own educated decision. You're listening to All Things Marcellus with me, Attorney Doug Clark. We'll be back next week. Have a great week, everyone.